We are live. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Okay, good morning. Good morning to both of you, and welcome to one of the final remote sittings of the Appeals Court for the 2021 court year. My name is Ariane Buno. I'm joined today on the panel with Justice Gabrielle Willehogen and Justice Eric Nyman. I recognize both of you, so I think you've both had arguments via the remote platform before. You know you each have 15 minutes to give your argument. And upon occasion, we have technical difficulties. They're usually resolved quite quickly. I will tell you this morning, I've had my own technical difficulties, which is why I have a different background. So we are very patient when these things arise, and we hope that you'll be patient with us if they arise as well. This case is Commonwealth versus Wilson Garcia, 2020-0366. Attorney Zandowski, please begin your argument.
Thank you. Good morning. May it please the court. My name is Matthew Zandowski, and I'm here representing the defendant, Wilson Garcia. This appeal concerns one issue, whether Mr. Garcia's motion to suppress was incorrectly denied, where there was no evidence that he made any furtive movements or he had any awkward placement of his hand across his body during an automobile stop. I'll start with discussing the exit order and the factors that went into the Trooper Phillips exit order. And so prior to ordering Mr. Garcia out of the car, Mr. Trooper Phillips did not observe Mr. Garcia make any movement whatsoever. And let
me just interrupt you for a second, because I find this case to be interesting because it's somewhat the reverse of what we usually see. Usually a motion judge or the Commonwealth is putting on evidence that there's been some sort of furtive movements or suspicious movements that lead an officer to believe that his or her safety is in peril or in danger. But here we have a different situation where apparently, according to the trooper, your client just sat very still, didn't move at all, and stared straight ahead. Why can't we look at that conduct in a similar way, even though it seems to be the reverse of what the cases generally rely upon? Still, it is conduct that is, may I say, unusual, or appeared unusual or peculiar to the trooper.
I think it's worth getting into detail about what you just said. So, with regards to the eye contact specifically, you can start there. That it appeared that he didn't make eye contact. Trooper Phillips had also testified that Wilson Garcia was specifically making eye contact until he stopped. So there wasn't a lack of eye contact throughout the stop. And then while he wasn't moving through the stop, I don't think there's information or any evidence concerning how long the stop occurred for. And it doesn't appear that the stop was of a particularly significant duration. There's not a whole lot of events that actually occurred during the stop. Trooper Phillips approaches the window, the passenger side window rolls down appropriately. He notices that no one's wearing seatbelts, so he asks for identification. People gather their identification. Mr. Garcia doesn't have his. They have an exchange about that. And
I believe the trooper said that he's willing to give his name, even though he doesn't have identification. Correct?
Exactly. Yeah, he's willing to give his name. Then Trooper Phillips notices he is actually wearing a seatbelt, so he doesn't need the name anymore. And Trooper Phillips testifies that he asks two questions: where are you coming from? Where are you going? And that's the extent of what's occurred in the stop. And so while Mr. Garcia hasn't made any movements, I don't think that the stop is of a particularly lengthy duration for not moving to be a suspicious activity. Also,
a question. It's actually a couple of questions. Let's say trooper comes up to a car, goes up to the passenger side, and the passenger is not moving, but the passenger is holding his arm up above his head like this and just keeps it there, stationary, doesn't move at all. I hope we can agree, the two of us, that that's not customary.
Yeah.
All right. So, and he doesn't move, and even if he was going to, scratch, whatever he was, if someone just stays rigid in a position that strikes you as unusual in the particular situation, can we agree that a trooper can reasonably make some inference from that regard? I'm not trying to get you to agree to what the inference might be, but that might lead to the trooper to think something is going on, something is odd.
I think that's actually similar to, I'm blanking on the case, maybe Johnson, where the passengers all held their hands outside the window immediately upon the stop.
Yeah.
And essentially the court held there that it was unexpected, but it didn't necessarily contribute to any safety concerns, but it was unexpected.
Okay, so let's say, so here, the officer testifies, the trooper testifies that he's holding his arm, I forget the exact words, but across himself, and just leaving it there. And now in the transcript, the transcript indicates that the officer demonstrates that position in the courtroom. And we don't have the benefit of seeing that, but the judge did. And without knowing what that position is, how can we say that the judge's conclusion that that position was across his waistband area is clearly erroneous?
Well, I think that we don't necessarily know what gesture he made. It is some evidence that there was a gesture, but we don't really know what he was describing. And so I think without that, we can't say it was specifically across his waistband versus upper stomach or kind of any other area.
The judge was wrong when the judge saw what the trooper demonstrated in the courtroom.
I'm saying we don't know what the trooper demonstrated, and so I don't know that the judge is.
Whose burden is that to reconstruct on appeal for us? I think it would be yours. So let's say that I can't do this on Zoom, but let's say I still can't do it. But let's say that the position was like this.
Okay.
Because that seems to me consistent with the transcript and the judge's findings. And the defendant doesn't move that at all. The trooper says he stays rigid in that position. And that's not a, let's say, natural position. Why doesn't that permit the trooper to develop a safety concern?
I don't think that there's evidence that it isn't a natural position or that it's an awkward position. It's an arm resting across a body. And
how do we know if we don't know what was demonstrated in the courtroom?
We're through Trooper Phillips' testimony that he didn't see it awkward. He didn't testify that his Mr. Garcia's hands weren't visible. So he's in full view there. And so I suggest that just the information, even specifically the judge's finding that it was across a waist belt isn't necessarily an awkward or unusual position. So
isn't it a reasonable inference? I mean, I'm looking at the hearing at transcript, page 12. The trooper says, I noticed his arm just kind of covering his stomach, chest area. Even when I first said, hey, no one's wearing a seatbelt, give me your ID, he didn't move, which he didn't move basically throughout the entirety of the stop, which to me, it's not normal behavior. So that combined with the demonstration of whatever sort that we're not certain of, And I think you also have, well, you can tell me, prior to the exit order, was the trooper aware of the prior firearms offenses?
He was aware that the owner of the car had a prior firearms offense, but that isn't connected to the operator or anybody else in the car. There's no prior information about any occupant.
But to re-articulate my question, why is that combination of factors that I just stated, that is the testimony plus the demonstration by the trooper in court, plus the prior notice of the firearms offenses, why aren't those factors in combination enough to justify an exit order under our case law?
I'd say that because the prior criminal activities weren't actually connected to anybody in the car, so it's just to the operator, that the hand placement isn't, I would argue, isn't unnatural or unusual, and doesn't occur for a particularly lengthy duration. And
is that a question of fact, though?
Well, we know everything that occurred in the stop, and so I'm not sure that it's a question of fact. I'm just, everything that occurred in the stop would lead me to say that it wasn't a lengthy stop, that he didn't leave the car window, he didn't run anybody's identification and come back, things of this nature.
Did the officer know that the driver was not the owner by the time he asked the passenger to step out?
There's no indication kind of where he learned anything about
in terms of the sequence, right? So all he really knows is that the owner of that car has these gun and firearm and drug charges, but he doesn't know that that's. I mean, why would he be required to assume that the driver was not the owner?
I don't think he'd be required to assume, but I think that it would be information that he could have easily testified to or looked up. It would be within his power to have resolved that for us. So,
are you saying he would have been required to know that?
Not required.
Or he could have a reasonable safety concern?
I'm not saying he would have been required to know that, but he could have, I think, looked that up, or he could have testified. I think his testimony was unclear, and so we're left with that unclear testimony, and so we can't make that inference. He wouldn't be required to, though. And so I'll run down a few other factors here. So again, there's no evidence that he was not in full view, that Trooper Phillips couldn't see his entire body or his hands. Within that, he didn't make any furtive movements. There's no indication that Trooper Phillips noticed any kind of weighted object, any kind of bulge in the clothing. We don't know what kind of clothing Mr. Garcia was wearing at the time of the stop.
Sorry to interrupt you, but since our time is almost up, I wanted to ask you a separate question. Let's assume for a moment, just assume that the panel determines that the exit order is justified. Then we have the issue of the pat-frisk, which is a separate issue. Now, again, assuming only for purposes of the conversation, of the discussion here, if the exit order is justified, as soon as your client alights from the car, he indicates or says to the trooper spontaneously, as the judge has found, lock me up. And the trooper says, he's a bit taken back by that, and says, do you have a firearm or do you have a weapon? He says, no, but lock me up. Why does that not provide a basis for the pat-frisk? Again, I know we have the issue of the exit order first, but why doesn't that justify the handcuffing and the pat-frisk at that point when as a result of that comment?
Okay. So I would argue that it's not a specific inarticulable fact that he is armed, that it is, I think, a somewhat.
Well, what would it mean? What would be a reasonable inference when an individual says to a state trooper, and we can quibble over whether or not this was a dark highway in the middle of the night, because it is just Route 7 outside of the Cranwell estate at 6 o'clock in the evening. So that point is well taken. What would be a reasonable, or let's put this, what articulable facts can be drawn from a comment like that, in your view?
Well, he has just been, his automobile has been stopped. There's not a particularly lengthy duration, or not a lot has occurred before he's been ordered out. So I don't think that it's reasonable to necessarily jump to weapon. It could be a reasonable inference, still could be that he was frustrated at the situation, an exit order. And
I was thinking it could be that, for example, he has a default warrant. It could be that he's carrying drugs, which in fact it turns as the trooper later discovers. But it could also be the fact that he has a weapon.
I suppose it's possible, but I don't think that it's a directly reasonable, specific and articulable fact that he has a weapon. And I think very briefly, it's also supported by the concerns that he had while he was in the car, that Mr. Garcia wasn't moving and he left his arm still across his chest. There's no indication that those actually persisted after he was ordered out of the car. And so we don't, presumably he has moved and that his arm is no longer across his chest. The trooper doesn't notice any bulge, any favoring of the sides, any kind of physical activity that would indicate that he's armed. And so with that, I think my time is basically up. So I will rest on my brief.
Your time is up. I'm going to check with the panel to see if they have any additional questions or follow-up points. And I see none from the panel. So I thank you very much for your argument.
Thank you.
Okay, I'll turn now to Attorney Reeves.
Good morning, Justices, and may it please the court. This court should uphold the denial of the motion to suppress for two reasons. First, Trooper Phillips issued a valid exit order as he had a reasonable belief that his safety was in danger based on the totality of the circumstances. Excuse me. Second, Trooper Phillips' pat-frisk was constitutional as he had a reasonable suspicion that the defendant, again, based on the totality of the circumstances, was armed and dangerous. With regards to the exit order, this court must ask whether a reasonably prudent person in Trooper Phillips' position would believe that their safety was in danger. And I would submit to this court.
Attorney Reeves, I'm going to interrupt you because I just want to ask one question to make sure that we're all on the same page. You would agree, I assume, that if we find that the exit order is not justified, then the pat-frisk is not justified either, correct?
That's correct.
Okay.
And I would submit that there are 6 specific and articulable facts to justify that exit order. The first being the knowledge that the vehicle owner was involved in significant criminal activity, especially the firearms offenses, being outnumbered 4-1 on a dark highway, the driver's inability to produce a valid license, the defendant's left arm covering his stomach and chest in a way that is consistent with concealing a firearm, lack of eye contact from the driver and the defendant, and finally, the defendant's lack of any movement during the entirety of the stop. I should say, even when he was asked for an ID, he continued to hold that concealing position that's consistent with carrying a firearm.
Where was the testimony that this was a dark highway?
I believe that would be based on the time and the date, given that it was around 6 o'clock in November.
Okay. This part of Route 7 is just is it 1 lane going each way or 2 lanes?
I believe it would be, I actually don't know, Your Honor.
Is it well lit? My experience, which doesn't matter, so it's what's in the record, but I don't recall that being a dark area. Was there any testimony, for example, that there were no street lights, that's not a well-lit area?
Not to my knowledge, Your Honor.
So where in the record does it support that finding of fact, other than it's nighttime? It could be nighttime and it could be incredibly well lit with the lights on at Cranwell and the lights on Route 7 in that part of the road. I'm not sure how that finding of fact is justified or supported by the record.
I would just submit that as this individual is being pulled off of a highway, that there would be a lack of street lamps or anything of that sort. So I would submit it's a reasonable inference for the court to draw.
So, geez, I think that's an awfully big jump. I don't see how that's supported by the record, and I don't know how that's not a clearly erroneous finding.
Your Honor, even if that fact was thrown out, even if the court finds that that's clearly erroneous, there's more than enough to justify the exit order and pat-frisk in this case. Again, there are still 5 specific and articulable facts that we have, especially considering the fact that the vehicle owner and possible driver, which again is unclear from the record, had previous firearms and trafficking offenses.
Let me ask you a question
The
that
fact led
was already
the motion
raised.
judge to find that based on the totality of the circumstances.
I'm sorry, Attorney Reeves, I think we had a little bit of a delay and I was interrupting you again. Can you hear me? Okay, so you appear frozen for the moment. I'm going to ask my panel members if Attorney Reeves appears frozen to you as well. He
Yes.
does. Okay. So if you can hear us, Attorney Reeves, just hold on for a minute because you are not communicating with us. Your screen is frozen. I'm going to ask our clerk to come back up and see.
We're live.
Okay, thank you very much. And we're resuming argument again in about giving Attorney Reeves about 12 minutes still to finish his argument. And I have about to interrupt you and ask you the following question. So now I will do exactly that. Judge Wolhogen brought this issue up earlier in the argument today, and that is whether or not the trooper was required to, or was it reasonable for him to infer, one or the other, that the driver, the operator of the car, was also the owner of the car. He did indicate that he determined by having run the license plates that the registered owner of the car had firearms and trafficking charges. But it is pretty clear throughout the testimony that he never determines that the operator of the car is actually the same person as the owner. That's not really addressed by the judge in his findings. So what do you have to say about that?
I would say that, again, this is, and even as my brother indicated, this is a stop that didn't take place for a significant period of time. And this is based on the totality of the circumstances, these are, this is an officer who approached the vehicle and realized that, there was a possible firearm concern in the vehicle. So I would submit that, I apologize for the court. If you could just repeat the tail end of the question, I seem to have gotten a little bit lost.
That's perfectly all right. Now, my question was, how reasonable, in your view, or was it a reasonable inference, the only inference, or what should we permit as a matter of law, an inference that the registered owner of the car is also the driver of the car?
I would submit that it's reasonable for him to rely on that information until such time as it's determined that it was not the case. And in this instance, he wasn't able to determine, or didn't have time to determine, it would seem, based on the testimony, because he had this safety concern for himself. It would be speculation for me to assume that he would have asked whether or not the driver was the registered owner of the vehicle after Mr. Garcia was ordered out and all of the events ensued. So I won't go into that, but I would say it's certainly a reasonable inference for him to rely on during this stop, which, again, based on the record, I can't tell how long it was, but I wouldn't assume that it would be.
Well, let me go in a different direction. He was alone when he made the stop, correct?
Correct.
But he had been parked in the Lee Fire Department in a heavily trafficked area. So when he first noticed the traffic violations, he was in an area where he would not have been in any kind of isolated situation. And as I understand the testimony from the trooper, he followed the vehicle for several miles and went right by the Lee Barracks. So at any point in time, he could have called for backup, but there's no evidence that he did. Is that a fair reading of the transcript and the evidence that was presented?
Yes, Your Honor.
Okay. And can one take that a step further and presume that if he was concerned for his safety, that he would have called for backup? When he stopped the car, he had the information about the registered owner's prior criminal history. Correct. And he did not call for backup at that point in time.
That's correct. And that fact alone did not indicate to this officer that he had a reasonable fear for his safety. They were the other specific and articulable facts that happened once he approached the vehicle, which indicated that he had a reasonable fear for his safety.
But the weird thing about the other facts is that they can be characterized as the people did nothing.
Yes, Your Honor, but I would submit that the absence of evidence is not the evidence of absence in this case. Mr. Garcia is behaving in a manner that is consistent with concealing a firearm, and although he's not moving, he did.
But no one testified to that in the evidentiary hearing.
I would submit that the Trooper Phillips's testimony saying that on page 12, he had a feeling that something along with the driver's history, something to him didn't feel right. That in combination with him testifying that he didn't move throughout the entirety of the stop. And again, on page 12, saying maybe he was holding a weapon. That's Trooper Phillips's training and experience indicating to him that the placement of Mr. Garcia's arm is consistent with an individual that's holding a weapon.
Well, but what he says is something didn't feel right, right? Quote, I just felt uncomfortable, end quote. And correct. I was, right?
And then later on, he says, maybe he was holding a weapon. So that's what I did. I asked him to step out. It was that training and experience that told Trooper Phillips that that placement of Mr. Garcia's arm across his waist belt area indicated that he may have been concealing a firearm. And that was the whole, one of the reasons that tipped off Trooper Phillips feeling as if his safety was in danger and leading to the valid exit order in this case. Now, I will admit that the more heavy lift for the Commonwealth is in fact the pat-frisk. But when you look at the totality of the circumstances in this case, when Mr. Garcia exits the vehicle, not prompted by Trooper Phillips didn't do anything other than escort him back to the vehicle, and he says, "Lock me up." Lock me up is not consistent with an individual that's merely nervous. This is consistent with an individual who has broken the law in some way, shape, or form.
And so are you saying that that is what gives reasonable suspicion that the defendant has committed or is committing a crime?
I would say that in combination with the previous factors at play provide reasonable suspicion that the defendant is armed and dangerous.
Oh, okay, but what's the test for pat-frisk?
The test for a pat-frisk is whether or not there is reasonable suspicion that an individual is armed and dangerous. It's not officer safety. Officer safety would only be for the exit order in this case.
It doesn't include the reasonable, well, no, that's right.
I'd like to ask you about, well, let me ask it this way. Is there an indication in the record that during his testimony, the trooper was motioning or mimicking to show how the defendant was covering his stomach or chest?
No, Your Honor.
Okay. So how could the judge make the determination as to what the trooper meant?
Based upon his words. If you look at the transcript on page 12, he says, "I noticed his arm was just kind of covering his stomach chest area." That in combination with the transcript on page 13, lines 7 through 14, when asked which arm did he have across his body, he indicates, so it would have been his left. And that's why I didn't see the seatbelt at first. And based on those two bits of testimony, I would submit that it's reasonable for the motion judge to find that in fact, Mr. Garcia's left arm was covering his waist belt area.
Except that they're almost contradictory, because as I first understood that, I thought the arm must be this way, because how else would it have obscured the officer's view of the seatbelt? And that's not something that could be called waist belt area.
Correct, but whether it was covering his, I would submit that in either event, this is still behavior that's consistent with concealing a firearm, which would both justify the exit order and would be a fact that is in Trooper Phillips's mind to justify the pat-frisk in combination with Mr. Garcia indicating.
How would we know that holding your arm this way would be consistent with concealing a firearm? There's no testimony to that effect.
Are you talking about there's no testimony indicating that his arm placement was consistent with concealing a firearm?
Yes.
Based on Trooper Phillips's training experience, this strange, unexplained body language by the defendant indicated to Trooper Phillips that, and I quote the transcript on page 12, somewhere in lines 14 through 21, maybe he was holding a weapon. So I would submit it's a reasonable inference for not only the trial court, but for this court to draw that Trooper Phillips' training and experience informed him that that strange, unexplained behavior was consistent with holding a weapon. He wasn't saying, maybe, my apologies, I couldn't hear the court.
How long had the trooper been a trooper?
For approximately 5 years. He was a police officer for 3 years and a trooper for a year and a half at that time.
Yeah.
He had also worked in Springfield, and that's where he learned that technique. It's on the transcript on page 11 about approaching from the passenger side to give him a couple extra seconds. He had worked in a high crime area in Springfield and had previous experience with armed individuals. And so all of this information is rattling around in Trooper Phillips's mind. When he approaches, I would submit that, he did not need net backup at that time. He didn't reasonably fear for his safety. Just because somebody has a record of previous firearms and drug trafficking offenses doesn't mean that something's going to happen. But he approaches the vehicle from that passenger side and then sees Mr. Garcia not moving at all. And at one point, not making eye contact and having this suspicious body language that's consistent with an individual holding a firearm. You know, I would submit to this court, it's a very low bar for an exit order. And if you look at the Sweeting-Bailey case citing Commonwealth v. Gonzalez, it says it does not take much for a police officer to establish a reasonable basis to justify an exit order based on safety concerns.
What about the pat-frisk, though? The pat-frisk, would you agree that the only thing that gets added to the mix is the defendant saying, "Lock me up"?
After he exited the vehicle?
Yes.
Correct. But even while he was in the vehicle.
So are you arguing that at the moment the trooper issued the exit order, it was reasonable to think that he was armed and dangerous?
There is testimony to support that. While Mr. Garcia was still in the vehicle, Trooper Phillips had a reasonable suspicion that he may have been holding a weapon. Now, lock me up was just, it seemed to be a little bit, how can I put this? It was the cherry on top, so to speak. It was the final piece that told Trooper Phillips, I need to ask this individual if he's armed, and which he did. And he asked him, do you have a weapon?
No. Yeah.
He didn't ask him, do you have contraband? He didn't ask him, do you have drugs? He had a reasonable suspicion that this individual was likely armed and dangerous. And based on that.
And so when the defendant says, I'm not, why doesn't that make a difference?
Because an officer is supposed to rely on their training and experience. And these traffic stops, you know, officers, I believe the Stampley case stands for the proposition that law enforcement officials have little time to avert the sometimes lethal nature of traffic stops. And so Trooper Phillips relying on an individual who's already behaving in a concealing way, having known the history of the registered owner's history with firearms and drug trafficking offenses, I think it's perfectly reasonable for him to assume, based on his training and experience, that that individual is carrying a firearm and to not listen to them when they say no. And
Okay, so your time has expired. But just one moment, I'm going to see if either Justice Wolohojian or Justice Diamond have a follow-up question for you. I see not. And I actually do have one follow-up question I neglected to ask earlier, and that is Mr. Garcia being held at this time? I see in the docket that it indicates that he was out on bail, but then he was held for 90 days. Looks like he was released on bail again in December of 2019. Do you know what his current status is?
I do not, Your Honor.
All right. I presume I never do this, but Attorney Sandrowski, looking as if you know, do you know what his current status is?
As of about a month ago, he was out.
Thank you very much. Commonwealth versus Aaron Faria, 2020-0890. Before we begin, I'll introduce the panel. My name is Ariane Vuno. I'm joined today by Justice Gabrielle Wolohojian and Justice Eric Nyman. As you know the rules, you each have 15 minutes to present your argument. If we experience any further technical difficulties, please be patient. And you've already proven that you have been, so we expect that you can abide by that request. And if we do have issues, you will not lose any time, okay? So that said, we're going to start with hearing from Attorney Benyon. Please begin your argument.
To the presiding justice, and may it please the court. So this is an issue that frequently comes up, and it's an issue that I feel is very important. While courts have tried to restrict this type of bad act evidence in the past, with all due respect, in my opinion, you have done a pretty terrible job. So that's what I want to talk about today. I hope we all understand why courts are leery of this type of evidence. It is prejudicial. It starts out prejudicial. And in my opinion, instructions that are given to the jury do little because of the problem with this type of evidence.
Now, let me just interrupt you for a second, because you've been in courtrooms and you know how solemn the experience is. And you've seen judges instruct juries, and telling juries that the jury has to listen to the instructions and to follow them. And in fact, even before they sit as jurors, they're asked whether or not they can follow the judge's instructions. But you're indicating, pushing the envelope and saying that that just does not work in your view. Is that what I'm hearing you say?
Well,
That is not sufficient to
I am not.
negate any prejudice that may come forward with evidence like the type of evidence that you're challenging here today.
I don't like broad stroke reasoning. I'm not attacking jury instructions, but I am saying that when it depends on what the evidence is and what you can reasonably ask reasonable people in a jury box to do, to forget and to overlook. And that's the problem.
Okay.
Look, the Justice Devens, who is a justice now long dead, who sat on the SJC, if you have my brief, if you will please turn to page 21.
I read that. I read the quote from the justice. It seemed as if it could have been written yesterday.
It could have been written yesterday, but the problem here is, and it sounds so much better if it comes from somebody wearing a black robe. You're amazed. But the problem here is that it's not making an impact, because in Justice Devens' opinion, written in 1882, and if you have it, you really should open it up, because I'm going to quote from it. It may be doubted, and this is at the bottom, it may be doubted, or it may be well doubted, whether the exceptions to the general rule of law ought to be further extended. But of course they have been. This is one of those cases where the exceptions have swallowed up the rule. And even though we have cases that talk about substantially relevant to the charge, or evidence should be excluded if risk of prejudice substantially outweighs the probative value, putting the word substantially in the law has done nothing. Because
I hear you on your argument. I think that in many of these domestic relations cases, the evidence comes in, we say to help establish the nature of the relationship between the parties. But that's where we've got evidence that, for example, or the defense is trying to point to, for example, a delayed reporting or something else where the Commonwealth wants to try to show why it was the victim didn't come forward earlier. So if we only had the assault on a family member charge here, I think it would be difficult to explain how this evidence came in. But that wasn't the only charge at this trial. There was also the witness intimidation charge. And could you please, if it was admissible in connection with that charge, then it's just admissible. And the judge gave a limiting instruction. Could you please maybe expand on why it is that the judge abused his discretion in admitting it, given the witness intimidation? Sure.
Let me just go to my brief and get the facts here. Hold on really quick.
As I understand it, that charge was based on a telephone call, or maybe more than one telephone call, to the victim in the hospital after the assault. And the Commonwealth's argument was to understand that what the defendant was constituted intimidation. You needed to know that was backed up by the history of physical violence.
Well, so going to let me just quickly get to my appendix now as well. As I look at the government's argument, they specifically told the judge they wanted this type of evidence in to show the hostile relationship between the defendant and the victim. But again, whether you're talking about an assault and battery or whether you're talking about witness intimidation, you can ask questions of the victim who is in the jury or who's in the witness box. The jury can view, based on her testimony and her reaction, whether she's credible or not. You can ask general questions like, what was the nature of your relationship? That's fine. If the government wants to lay some kind of a foundation to show that there was hostility or contention in the relationship, that's fine. But what happens here is you have the government who has charged him with assault and battery, and then and also witness intimidation, but then brings in extra evidence that happened in the past. It was never charged. It was never discussed before. And again, that's one of the problems. Again, going back to Justice Devin's opinion, you're putting something, you're surprising the defendant with something that's very difficult to rebut because it's just coming out at that moment.
Let me ask you this, Attorney Fenton, if I may. So you've indicated that it would be permissible, in your view, to simply have a victim in similar circumstances to testify to the nature of the relationship. It was hostile. It was tense. I was afraid of him. And those kinds of broad statements would be permissible, but specific conduct. Why were you afraid? Because he hit me. Why was it tense? Because he would not let me have a cell phone, and he would not let me see my friends, whatever, right?
Not having a cell phone would be fine, because that's not talking about assault and battery. That's the charge. That's the charge that he has. And when you put in the jury's mind,
I see your point, but let me finish. So those kinds of things would be admissible. But what if the only evidence of the hostile relationship is physical violence? And then would your view change if the victim testified to a hostile relationship, then was cross-examined to a point where her credibility was significantly diminished to the point where it's evident? Could that victim then be rehabilitated with direct evidence of incidents or not? You would say no.
Look, the
and that's kind of the problem in these kinds of cases, isn't it? That's where the judge has to walk that line.
Well, no, because when you're charging somebody with assault and battery, and then you bring in evidence that it occurred when the government indicted it, that we're talking about at the McDonald's drive-thru, but then you bring in evidence that it occurred twice on some unknown previous event. She couldn't remember where it occurred in one event where he hit her in the car. That's when you're getting into the point where the jury has to be then, they understand, in my opinion, what's going on. This is a piling effect. And that's all it is. Because the government has the victim in the witness box. She testified as to what occurred at the McDonald's drive-thru. The difficulty here is that the government is concerned that maybe the jury, in my opinion, the government's concerned that the jury might not accept her testimony as credible. And so they use this tactic to pile on to cure any credibility problem before it even begins.
So one of your, I'm sorry.
Oh, go ahead.
It seems to me that your argument is essentially that once this information gets in front of a jury, they are poisoned, and they are not going to pay attention to what happened in this case because they have a history of other events, and the jury is essentially tainted. Is that what you're saying?
I'm going to say it differently, because the way you say it, I don't like, because it makes it sound like I'm broad stroking again with the law, and I'm not. What I'm saying is this. When the jury or when the government is required to prove a certain set of facts, and like the elements of assault and battery, and then you show that you put evidence before the jury that he has done this before, the same elements, that's never been tried before a jury. We don't know. I mean, maybe had she testified to those other events, and that was what the charge was, maybe the jury wouldn't have found her credible. I don't know, because she couldn't remember where it occurred. Maybe that would be enough. But
Your concern is the impact. Your
jury.
concern is the impact on the jury, correct?
Yes.
Okay.
That is the impact.
Assume we agree with you. What do we do then in a case like this, where in addition to the limiting instruction, and I understand your concerns about that, where the jury also found the defendant not guilty of one of the charges? Doesn't that tend to suggest that this was a jury that was thoughtful and didn't merely say bad evidence, prior bad acts, bad guy?
No, because they did do that, in my opinion, with respect to the assault and battery. But if you go look at the
but not the other charge.
The other charge was, I think, pretty clear that it, because I'm not even sure it was. Hold on. Just because the jury splits the verdict like that, I don't think that tends to show one way or the other. I mean,
why not?
Because the jury being a black box, there's so many ways that a jury could reach that, and I hate to.
Would you agree, Attorney Benyon, that our case law, many of our cases do say that is a consideration, that is a factor to consider?
I do, but it's a pretty lousy factor, especially when we're talking about this type of prejudice. A person who comes into an American court needs to feel like the government is proving their case that they indicted, and that's what we're focusing on. But that's not what happened in this case. And I understand why the government likes this evidence. As I put in my brief, it is a drug, and no DA can resist it. And courts are pushing this because it's easier. It does take care of any problems that the jury might have with respect to believing the victim.
I have a hard time, with all due respect, and I maybe didn't catch it. I'm trying to find out what your argument is as to why this was not admissible on the witness intimidation charge.
Because I guess
what were the statements that were made to the victim in the telephone calls to the hospital?
Hold on, let me pull that up.
There's a snitch.
Whatever they were, why is it that the nature of the relationship between the defendant and the victim do not bear on the meaning of what the defendant said to her during those phone calls with respect to whether or not they constitute witness intimidation?
Because again, you have the victim in the witness box in this case. She can testify as to how she felt if she heard a statement.
Why can't she say, I was intimidated? Why? Because he's beaten me in the past. In fact, that's how I interpreted them. That's the nub of it.
It's not a general witness intimidation. It's witness intimidation with respect to the events that occurred in this case at the McDonald's drive-thru. We're talking about events that occurred in the past, of which
witness intimidation charge based on. It wasn't what happened at the McDonald's drive-thru.
No, I understand that, but the phone call did come from the events of the drive-thru. I understand they're separate, but when we start going into other events, again, that's only curing the government's problem with respect to the victim. They have her on the stand. She can testify. The jury can believe her or disbelieve her. All this is a crutch for the government to get the jury to get on their side and not like the defendant. It is a piling on. My time's up.
Yeah, we've gone into the next clock a little bit by virtue of, there we go, of the how this functions. Thank you very much, Attorney Benyon. I'm just going to check with the panel to make sure they don't want to follow up with you. And I see that they do no further questions, so you may rely on your brief. Attorney O'Neill.
Yes, may it please the court. What my brother appears to have presented to the court is an idea, but has not met his burden of showing error. And obviously that's why we're here today. The judge in this case clearly, and we have citations in the brief and I can make citations here, clearly weighed the probative versus the prejudicial for purposes of two instances where the defendant had previously attacked the victim. One was in November of 2017, one was in December of 2017, and the indicted charge was January of 2018. In addition to, as the court has pointed out, and I think Justice Wolahojian has focused upon, there was the assault and battery charge, but there was also the witness intimidation charge. And as you can see from the record, in the record appendix, there are the motions in limine, which were no surprises. Both parties filed motions in limine regarding past bad acts. Now, the argument was primarily one focusing upon, we want to introduce it for purposes of the witness intimidation piece and to show the nature of the relationship between the parties and the relevance of that vis-a-vis the phone calls she received at the emergency room. That seems to be the reason for this. Why he should be protected from his prior activities when they support an argument in the elements for witness intimidation has not been shown, and nor I think would you one be able to show that.
But
because
you're talking about, I'm sorry for interrupting, but you're talking
Sure.
about the point that Mr. Benyon's making, and I know he doesn't like the way I'm articulating his case. The point that I see him making is it's not about protecting or not protecting the defendant's prior conduct. It's a way of backdooring in the exact same conduct and effectively convicting him based upon uncharged conduct.
Except
I mean, the gravamen of his argument is this is exactly what you're charging him with now. And that prior information, we're almost taking it as if he's been convicted of that when he's never been charged of it. And that's a real poison to a jury, as I see it.
Right. And except as you pointed out, Justice Naiman, he didn't get convicted on the witness intimidation piece. So it did not poison the jury.
No, but it may have, because it may have poisoned the jury on the charge that it buttresses in that way. So
Well,
in other words, it turns out that the way I look at it is, if the witness intimidation charge weren't in this case, it's very hard to see how this evidence should have been admitted on a standalone assault charge that is nearly identical to one of the prior bad acts. That seems to me to carry a lot of danger with it. And that's the charge. It came in, it was argued to come in on the witness intimidation charge. They didn't convict on the witness intimidation charge, but they did convict him on the charge where it would tend to sway the jury. And I'll note further, the limiting instruction did not say you can only consider this evidence vis-a-vis the witness intimidation charge.
Correct. It was not asked to be said that, and the judge did not do it sua sponte. But the judge was was focusing upon, as did the parties, the witness intimidation charge for the introduction of the bad acts evidence. But it wasn't exclusive to that, but that was the focus.
So how is it that the nature of the relationship has any bearing at all on the assault charge?
If I may, Your Honors, even my brother concedes in his brief that there is a surfeit of case law that provides that it absolutely is.
But that's usually to explain something that the jury might not otherwise understand, like a delay in reporting, or something that you couldn't, that the Commonwealth says it would not be fairly depicted or understood without that evidence. And here, I don't see that argument being made below, and I don't see that argument being made here. What is it that it bears on in this particular assault charge?
Well, I think the argument is made in the motions in limine, and I think my sister who crafted the brief made it there as well. And in both, they are stating, and the judge stated, it's to show the pattern of conduct. It's to show the relationship between the parties. That helps to explain the why of the event. The thing of it is, Judge,
excuse me, Attorney O'Neill, this seems to me very dangerous where you're heading. Because the why of this event is he did it before, therefore he did it this time?
No. It explains the nature of their relationship.
Which
So
is
yeah,
every
if
time they're in
one,
a car, he's going to hit her?
say it again, I'm sorry.
Which is what? Every time they're in a car, he's going to hit her?
No, it doesn't show every time he's in a car, it's going to hit her.
Um,
It shows that they have a tumultuous relationship.
How is that relevant to Justice Justice Williams' point that Attorney Benyon was also making earlier is, did you need that evidence? Was it an abuse of discretion? Did you need that evidence to prove the elements of the assault and battery? Especially here where you have a situation that people saw and heard at the McDonald's. There was some tape recording. There was the observations of police officers. There was an admission into the hospital. Often, as Attorney Wilhogen has pointed out, this evidence is necessary to show an absence of something that you might not have. But in this case, let's just say they didn't have any relationship, and they got into an argument at the bar, and they left together, and then they went to McDonald's, and then they had this ensuing argument. This is not a case in which there was a positive evidence regarding the underlying charge, is my point.
And if that's the case, if there's no positive evidence, meaning it's cumulative, then there'd be no prejudice as well. But I guess.
Well, I guess that's the decision for the trial judge to make, because as defense counsel here concedes, there is many cases that support what happened here.
Yeah.
On the other side, there are many cases, starting back from Conwell versus Jackson, that says the general character of a defendant cannot be shown to be bad.
Right. And the general character of the defendant was not what they were looking for here. Because if you look at the state of the case, the defense's argument throughout was the general character of the victim. Don't believe her. She's no good. She lies. She wasn't even in the car. He wasn't even in the car with her. That required the Commonwealth to respond. So in terms of whether or not she's believable, they have the video, they have the medical records, they have her statement. And yes, they buttress her statement by saying she isn't just a stranger who's making believe that this guy was in the car with her. And oh, by the way, you also have the testimony of the two police officers at the emergency room, one of which heard what was said and the other didn't, stating that, yes, there are threats or there's something being mentioned on the phone very loudly to her that's upsetting her. So in terms of what I'm hearing from the court, and please correct me if I'm wrong, the court doesn't seem to have a major problem with it coming in for purposes of the witness intimidation, but it feels like it's cheating to the court if it comes in also for the purposes of the other charge. Because honestly,
we haven't reached any conclusions whatsoever on this case.
Okay.
I will follow up. You can be absolutely sure that we have not yet decided how this case is going to be turn out.
But honestly, honestly, in terms of the case law on this, the case law I feel confident in saying completely supports the Commonwealth's position. The case law, even the most recent cases cited, the Fasella case, the Pino case. I mean, in the Pino case where you had a mother's, it was a murder case with a baby, and they were getting into evidence the mother's relationship with the baby. And the standard that the court presented in Pino was, and I quote, "The trial judge's decision will stand unless we conclude that the judge made a clear error of judgment in weighing the factors relevant to the decision, such that the decision falls outside the range of reasonable alternatives, and they're looking at the factors of probative versus prejudicial, which the judge did on the record. They're looking at limiting instructions. She not only did them when the testimony came in, she repeated them in the general instructions. We have the cumulative evidence. I won't repeat that. We have all of this that supports what the Commonwealth did here. So I would suggest to the court that my brother's argument that, this just isn't right, or I'm not being as articulate as he was, but I get it. I do get it, but it is fair. And it was a fair trial, and it is fair because the court has.
Let me also ask you this, because I'm curious if you're familiar with anything along these lines. There's been many studies, for example, that have been conducted about victims of sexual abuse, and that's one of the reasons why we have the rule that was first called a fresh complaint, now first complaint, to explain why there could be a delayed disclosure, et cetera, et cetera. And of course, there's been many studies about the effects of domestic violence on victims. Should that be something? Are you familiar with any studies, or in particular, should that be something that the judge is entitled to consider? This is, in a way, a softball question to you, but I'm just curious if you have any solid information or any other cases that have addressed this issue.
Okay, it's an unexpected softball question. No, am I familiar with a particular study in terms of allowing more?
And let me be clear: a study that's been quoted by a court, not just in general.
Okay, I am not aware of a study that, if I'm understanding you, would provide more latitude for a victim.
Nothing similar to like the doctrine of first complaint, something like that, right?
Yeah. No, I'm not aware of that, of such a study, which doesn't, I'm sorry, in terms of what I'm aware of, doesn't mean anything, because it could very well be out there. But I'm not aware of it. No, I think that in this particular instance, it's clear that this comes in without question for purposes of witness intimidation. I would also argue to the court it comes in without question for purposes of the assault and battery charge as well. And I would further point out that my brother has failed to show the prejudice, particularly in light of the witness intimidation charge, he being found not guilty on that one. And what most importantly I would stress to the court is that the judge here spent a lot of time on this issue, gave it a lot of thought. It wasn't a willy-nilly introduction.
Excuse me.
I'm sorry.
I want to just focus on what you just said about prejudice. So with respect to the witness intimidation charge, the evidence, as I understand it, came in to help because it bore on what the meaning might be of the statements that the defendant made to the victim over the telephone.
Mm-hmm.
And it clearly did not have an unduly prejudicial effect on the jury with respect to that charge because they acquitted him.
Mm-hmm.
However, I have yet to hear any explanation as to how the evidence would bear on the assault charge, except in terms of propensity. And in that sense, there may be prejudice demonstrated by the fact that they convicted him on the assault charge and not on the witness intimidation charge. Can you perhaps address that?
Well, as the court stated in her ruling, the pattern of conduct was the reason why she thought it was.
But how is that not propensity?
Well,
on the assault charge?
Because pattern of conduct is shown as relevant for admission for purposes of a charge. You may
cases, for example, where there's a question about the identity of the defendant. So you need to try to show, this thing happened in exactly the same way 3 previous times, and we know the defendant did it on 2 of them. Therefore, he must have done it on. He's the defendant and he's the perpetrator in the 3rd. But there are none of those questions here. This is, as Judge Vuno said, an observed event, recorded on video, reported promptly by the victim, responded to promptly by the police. What does it go to with respect to this assault charge other than propensity?
I'm not sure how better to describe pattern of conduct here when, as I mentioned earlier, the defense was an attack of the victim and her credibility from beginning to end, opening to closing, and cross-examination of the victim. It was an attack of her credibility. So in order to substantiate her credibility, the prosecution is able to ask questions of pattern of conduct, which corroborates her credibility. Now, it may be that you see that solely as propensity. I would suggest to you that's not how the courts have read that and not how the courts have found that. So in terms of this particular case, with great confidence, I say that the judge acted well within the law when she made the decision that she made. So I would suggest to the court and ask the court to affirm, because Her Honor did the correct thing here and did it very carefully, and the defendant got a fair trial.
Thank you very much. Your time has expired, but I am going to determine whether the panel has any follow-up questions, and I see none from either one. Thank you very much for your arguments. They were very helpful, and we appreciate passion in the arguments as well. And thank you also for being available to come to present your argument earlier than had been.
All right, we're live.
Okay, thank you very much. Good morning and welcome to today's remote sitting of the appeals court. I'm going to call the case and then introduce the panel. This is Jared Seth Katsiani versus the Boston Redevelopment Authority, 2020-0619. My name is Ariane Buno. I'm joined today by Justice Gabrielle Wellhogen and Justice Eric Nyman. We will be hearing your case today. You each have 15 minutes to present your argument, and there is no rebuttal in the appeals court. I'd just like to remind you that the platform is such that upon occasion, we've experienced some technical difficulties. If that happens, please be patient. We will be patient with you. You will not lose any time as a result of any difficulties that may or may not arise. Attorney Katsiani, you will present your argument first, and you have 15 minutes to persuade us of your point of view. Please start.
Thank you and good morning, Your Honor. My name is Jared Katsiani and I am a pro se plaintiff. May it please the court. This appeal is necessary due to the lower court ruling based on the wrong statute, the Boston Zoning Code, which resulted in the court's failure to review defendant Boston Redevelopment Authority's binding conduct under the correct statute, Massachusetts General Law, Chapter 121B. The lower court's ruling is unrelated to the appellant Jared Katsiani's claims and inapplicable to the matter in dispute. The legal issues in dispute are the BRA's termination of the deed, land disposition agreement, and the rights of appellant Katsiani to use the land for Harriet Tubman House Community Center on parcel 17. The court's error of law ruling on the wrong statute, the Boston Zoning Code, and a non-existent zoning remedy led to the court's failure to substantively review appellant's claims and the exigencies justifying his preliminary injunction request.
Can I ask you a couple of questions to clarify the record for me? When you argue that there is no procedure that's going to or presentation to the Boston Zoning Board, to the Zoning Board of Appeals either, are you suggesting is that because there is no reason for this issue to be heard by them, or because you as a person who is not in a butter will have no redress, should that be the case?
The former, Your Honor.
Okay.
This project was, I believe it's called as of right, or it was within the zoning height limits. So it had no reason to go to the zoning board at any point.
Okay, it's only a change of use and not any other reason for it to go before the board. Is that right?
Correct.
Okay. So my next question, go ahead.
On that point, and I'm so sorry, Justice Juneau, but on that point, can't you challenge the use to the zoning board when the building permit is issued?
Your Honor, not that I'm aware. The project would never go before the zoning board for permitting either. So
No, but you could, so that, I mean, would you agree that they need to get a building permit, even though it's within zone, dimensional requirements of the zoning code?
yes, they do need to
Okay,
get a permit.
and so then you would seek some kind of enforcement from the building inspector. You would write a letter to the building inspector saying, I think that I challenge this project because of the use. And if the building inspector agreed with you, fine. If the building inspector disagreed with you, then you could appeal the building inspector's decision to the ZBA, the Zoning Board of Appeal. Isn't that correct?
Your Honor, I don't feel confident answering that one way or the other. I believe that this case revolves around the change of use, but it also revolves around the termination of agreements within the South and Urban Renewal Plan that were binding. So there's multiple issues, and this is the reason I brought the case.
I suppose it's possible that the building inspector doesn't have authority to interpret the various agreements or the deed. It just goes by what is the current situation. I don't know. I mean, it seems to me a little bit of a puzzle.
Yes, Your Honor.
Do you agree that USIS owns the building?
I do, Your Honor. They own it conditionally to use it
Okay.
as a community center.
And so your view is that can never change ever.
As long as the South End Urban Renewal Plan is in force, which it is through at least 2022, that's correct.
Okay, so it's also your view that plan cannot be modified in any way?
Correct.
Okay, but isn't there case law that indicates that one of the principles of these plans is that they are encompass a large amount of square acres, and they go on for a long period of time, and what could be necessary today might not necessarily have been what's important or necessary 30 years ago or 20 years from now, so to speak. So doesn't the plan itself allow for some modification to if necessary?
Your Honor, the BRA argues that under section 1201.
Mm-hmm.
However, in my case, my complaint, I argue against that. So I have citations in the briefs why I think that they're arguing under what they call a non-binding minor modification.
Mm-hmm.
But what I'm arguing is that it is not non-binding, it is binding.
And you're saying it's binding and substantial and material is your view, right?
Correct.
Well, one of the issues that's been raised, and of course, I'm sure you're prepared to answer, is whether or not you as an individual who's used the Harriet Tubman House or lives in the community has standing to challenge the procedures here. Do you want to talk a little bit about that?
Sure. This is, as you know, I'm a pro se plaintiff, so this is my first time with oral arguments. Am I allowed to read from my oral argument with my answer, or do I?
Absolutely, you may respond to the question any way you feel comfortable.
Okay, thank you.
And you're doing just fine, by the way. Maybe your first time, but no worries.
Well, thank you. So in answer to, I'm just going to jump ahead to the section I have about my harms. Okay. Well, I'll just speak extemporaneously then. When I brought this complaint in January of 2020, my original intent was that it was going to be, I was going to add other plaintiffs, and I made that motion, or I made that
representation to the judge.
Exactly. And unfortunately, the lower court only gave me 7 days. I did not have time to add the other plaintiffs to perhaps create a class action suit. But both myself, who I estimate I was in the center and used it both professionally and also recreationally and to attend events and art exhibits, et cetera, and as an adult tutor as well for adult ed, at least 800 times in a 30-year period. And it's true, I'm not in a butter. I live less than half mile away, though, on Massachusetts Ave, just several blocks away. There are many other people in the community who I believe are also harmed irrevocably. I mean, the building has now been demolished. So, you know, unless another community center can replace that on the land, they've lost a vital community asset that they relied on for generations.
As I understand the plan, it does involve the construction of a new community center.
Your Honor, the first floor will contain a community space, but again, that's not, that's a tiny fraction of the overall use of the building, and it's still a modification to what the site and the land was supposed to be for. And may I add also that parcel 17, I think the BRA argued that the original use was for residential and it's just returning to residential. But parcel 17 didn't exist before the 1965 plan. It was created by melding two separate parcels together in 1970, specifically to create the Harriet Tubman House as for recreational and office use only.
A procedural question that I had, when your preliminary injunction, your motion for preliminary injunction was denied, did you seek any review from the single justice of the appeals court?
No, I did not.
Okay. I didn't see anything in the records. I just wanted to double check.
Thank you. May I ask a procedural question as well? When the justices ask questions, I see the clock is still running, but do I still have time to complete my oral argument? It's going to go over 15 minutes at this point?
No, you will only have just about under 6 minutes to complete your argument. It's common that the judges on the panel ask questions so they can get right to the points where they have issues. I can assure you we've read everything that you've submitted before you started your argument, so we are familiar with your complaint and with everything that you've submitted previously, and so we like to focus so that we can answer the questions that we have. But the time is yours, and with no other questions in front of you right now, please go ahead and tell us what else you'd like us to know.
Okay, thank you. I had 13 pages, about 13 minutes, so I won't get through all that. I think I'll start later on. From the deed. Okay.
So I think your point is that the deed is pretty clear, if I understand it correctly, that these covenants run with the land and that they can't be changed.
Yes.
In your view.
The BRA and United Southland Settlements, commonly known as USIS, must remain in compliance with the plan and agreements until the end of the plan. The agreements are the final governing authority for Parcel 17's use through the end of the plan. There is no language in the LDA or the deed for either USIS or the BRA to break the agreements. There is, however, substantial language expressing they cannot. And these are direct quotes from the deed between the parties BRA and USIS. Quote, the parties agree that all obligations of either party in the agreement or in this deed, which by their own terms are to continue beyond the issuance of a certificate of completion pursuant to section 304 of said agreement, shall so continue. And that's addendum at 282. Again, from the deed, the grantee for itself and its successors and assigns covenants, promises, and agrees, A1, to devote the property as defined in the agreement to the uses specified in the Southland Urban Renewal Plan and to comply with the requirements therein specified, and not to use or devote the property or any part thereof for any other use other than the said permitted uses in the plan. That's
May I ask you a question?
Yes.
Is your position that under no circumstances at all could the use of this parcel be changed? Or is your position that there are certain conditions under which the use of the parcel could be changed, but they're not met here?
Your Honor, my condition is the former, as long as the Southland Urban Renewal Plan is in existence, which it still is. Once that expires, then...
So your position is there is no possible way to change to allow a different use of this parcel, period?
During the South End Urban Renewal Plan, yes, correct.
No matter what happens.
Correct. Finally, I note for the court several other factors which are covered fully in the briefs. The BRA has not defended itself to date regarding termination of the governing agreements to accommodate the sale. The BRA stated no reasons to the BRA board to justify the modification within the parameters of GL 121B. The BRA offered the board no reasons, aside from construction of 66 luxury condominiums, for modifying the parcel and terminating the agreements for parcel 17 to the BRA board in the board memo prior to their vote. The BRA also did not inform the board the agreements remained in effect at the time of their vote, meaning it cannot be known past speculation the board knew they were in effect at the time of their vote. The BRA held no hearing before the board vote, despite claiming in their answer below that they did. The BRA claimed parcel 17 was slated for housing in the original plan. However, parcel 17 did not exist in the original plan, as it was specifically created 5 years after the plan in 1970 for the explicit purpose of construction and operation of the Harriet Tubman House Community Center. It is with these points in this argument, along with Katziani's briefs and record on appeal, that Katziani respectfully seeks this court as the proper jurisdictional body to, number one, stay the land use modification to parcel 17 in the South End Urban Renewal Plan approved by the BRA board on December 12, 2019, and two, vacate the lower court order of judgment on behalf of appellant defendant Boston Redevelopment Authority, or three, stay the land use modification to parcel 17 in the South End Urban Renewal Plan approved by the BRA board on December 12, 2019, and four, remand this matter to the lower court for trial on all issues. Thank you.
As a practical matter, let me ask you one last question. You've indicated that the building has been demolished, and I believe that the brief of the BRA also indicates that. So as a practical matter, what do you see as, how would you like to see the outcome of this case?
Your Honor, I would like to see that the land reverts back to the community so that it is, instead of the condominiums being built there, a 100% community center is built there, because the community now,
Okay.
we're left with nothing. Thank you.
Thank you. Thank you very much. Any further questions from the panel for Mr. Katziani? No. Thank you very much for your argument. We'll turn now to Attorney Chacon.
Good morning, Your Honors, and may it please the court. My name is Denise Chacon for the Boston Planning Development Agency, doing business as the Boston Redevelopment Authority. The Superior Court correctly ruled in this matter that appellant has no standing. Appellant has no ownership interest in the project site, nor is he an abutter. Appellant makes no claim, nor could he, that BRA did not follow the procedures of Article 80. He is merely a private citizen who disagrees with BRA's legislative conduct. Case law has made it amply clear for many years that a person in this position has no standing. The Supreme Judicial Court declared over 20 years ago in the St. Vital's case that an individual who is not an owner has no right to challenge the BRA's urban renewal conduct. This was confirmed as recently as 2019 by the Supreme Judicial Court in the Marchese matter, where the Supreme Judicial Court again held that an individual to challenge an administrative agency must show that the agency breached a duty specifically owed to that plaintiff. And here, the BRA's legislative mandate is to promote sound community growth and to ensure long-term stability in its urban renewal plans. That duty by the BRA negates any speculative or indirect concerns raised by this appellant. As the Enos case declared, standing is not measured by the intensity or fervor of one's advocacy. It must be correlated with his legal relationship with the project site and with the conduct of the agency, and there is none. The appellant cites no case law because there is none in Massachusetts that supports this type of standing. On that basis, the Superior Court decision should be upheld.
I have a couple of questions because I have to say this is a new area of not entirely law, but the South End Urban Renewal Plan I'm not that familiar with. So I have a couple of questions that really go by way of background. Let's assume that the plaintiff has standing. Let's just assume that. I'm not asking you to agree. I'm just asking you to assume it. If the plaintiff had standing, is the BRA decision appealable? And if so, to whom?
If the plaintiff had standing, there is still no way to appeal it. The judicial review under Article 80, which is what was happening to enable this project, Boston Zoning Code Article 80, provides that the BRA's conduct is essentially legislative in nature. It is a discretionary, non-binding analysis by urban planners that is then funneled either to the Zoning Board of Appeal or is then given for part of the issuance of the building permit. Essentially, the BRA's conduct is an interim step. There are more things a developer must do before the municipality makes a substantive decision.
Can the BRA's decision be reviewed in an appeal from the building inspector's issuance of a building permit?
Yes, the appellant or any aggrieved individual may seek an appeal of a building permit, which is issued by the building inspector of the city of Boston, and that did not happen here. The appellant did not seek.
And as part of that appeal, the review of the BRA's change to the use of the parcel, that's open to review as part of an appeal from the building inspector?
I doubt that it would be in this circumstance, Your Honor, because of the uniqueness of this being urban renewal land. So under the South End Urban Renewal Plan, Section 1201 specifically states that the plan may be amended. So I do not believe that an individual appealing the building permit would have grounds to challenge that conduct. It goes back to the issue of St. Vital's.
To be frank, it seems weird to me for any governmental or quasi-governmental decision to be completely unreviewable by anybody, which is what I hear the BRA to be arguing.
Well, the appeals court has made this ruling before that the Article 80 conduct, this particular unique aspect that we're under, is not reviewable. The HRPT case, the Alford case, and it goes back again to the nature of what the BRA is doing. It is an interim, non-binding step, except it's true in regard to this point we're discussing under the urban renewal plan.
So does the appeals court decision say ever, or that they're reviewable if it's appealed as part of a later stage of the process, a final stage?
Yes, that is what the Alford case and the HRPT case said, that the substantive act is by the zoning board of appeal or by the building inspector.
Okay, so but then that's what's bothering me, because I just heard you say you didn't think that this particular decision could be reviewed on an appeal from the decision by the building inspector.
It's because the Supreme Judicial Court back in the 1970s in the DCA case stated that urban renewal agencies have the discretion to oversee this unique statutory instrument called an urban renewal plan, and that the ability to make changes will be allowed so long as it is not material or substantial. And if it is material or substantial, the BRA's conduct must be reviewed by the state entity that oversees urban renewal plans. And so here,
And who brings it to that person? I'm sorry to interrupt. In other words, once you determine the substantial or material, or you determine it's not, so you've moved forward, then who brings that to a state agency or to a court?
well, like in the Central Steel case, that was brought forward by the owner of the parcel who was affected by the urban renewal plan in that case. So it goes back to the core of the problem here is that Mr. Katzian does not have standing to appeal any of this.
So Justice Wolhojan's point, or one of her points that she's making, the way I see it is that, well, then if only somebody with that kind of a direct interest can do so. Basically, here you're saying only uses can challenge this, right? In this particular case. So
Sorry.
really it's not a non-binding decision here. It is in practicality binding. Because
The
if uses is
decision
not
under the
interested in
urban
it-
renewal plan, yes, that decision to make a change in the use of the parcel is binding on the redeveloper, basically the 566 Columbus LLC that is now the owner of the project. That is a binding decision on them. That arguably, I guess they could appeal, like what happened under Central Steel, to say that it's a substantial and material change not permitted under the urban renewal plan. But here, the change was to return the parcel to its original use, which was housing. And the BRA used its discretion to determine that housing is a critical need in the city of Boston.
All right, but those seem to me to go to the merits of the decision, and I'm really trying to get my finger on what looked to me in the BRA's brief to be an absolute position that the BRA's decision is unappealable by anyone. And I hear you perhaps refining that argument now to say if it is appealable by someone who has standing, which is limited to the owner of the parcel. So let's say USIS. And then can you please tell me how would a person with standing appeal the BRA decision?
Your Honor, are you referring to the BRA's decision under the urban renewal plan to make this change to the parcel?
Yes.
Yes. Well, I believe then that would be a complaint in the nature of certiorari to the Superior Court, and then a review of the administrative record as to the agency proceedings.
So it is judicially reviewable.
Yes, that's true. For someone that has standing, then under section, you could challenge the urban renewal conduct in regard to a change in use. And some of the plans don't allow for it. It could be the contract language of the urban renewal plan itself doesn't permit modification, but that is not the case here. Under the 1965 South End urban renewal plan, it is crystal clear that BRA acted within its rights and still sent the notice of modification to the state and to every legislator who has this parcel within their district. So it's not like this was done without transparency in the dark of night. This was part of a long public process that had begun in 2019 with the developer having many community meetings. And yes, there are some people that don't agree with the way this is being redeveloped, but that is not a reason to overturn and to invalidate the BRA's conduct. There is no basis in the case law to do that, not only because of standing, but also as what we're talking about under the modification under section 1201, just as a matter of contract interpretation. And further, the point we've already referenced, the fact that the Article 80 conduct itself is legislative and not judicially reviewable.
But see, that's where you lose me again, when you
Right.
make that last point.
So playing out Judge Wolahojan's earlier question, you'd say, sure, they can bring an action in cert, in the nature of cert. It wouldn't be successful, but they could bring it.
Well,
And you really have to wait until there is an action, such as action by the zoning board or some subsequent action, before you really could make a legitimate challenge. I mean, it seems to me that's effectively what you're saying.
yes, Your Honor, that is the precise point. And that is what the cases have held throughout the years. This is not a novel concept that I made up for this case. It is the essence of the fact that the BRA is composed of experts and that we want to mitigate the impacts of development, and we want that analyzed carefully. And then the decision that comes out of that is non-binding and a recommendation to the next level, whether that next level is the Zoning Board of Appeal or.
Again, you said non-binding, but in this case, in practicality, it is binding.
In regard to the urban renewal plan decision under section 1201, because there were two things that were happening here. There was large project review under Article 80, and then there was the urban renewal conduct. So yes, Your Honor, the decision to modify under section 1201 was essentially binding unless as we talked about, USIS or the redeveloper had appealed that.
Let me ask you a slightly different question. I don't want to interrupt the train of thought here, but What do we do with the record? For example, you've just said that the community, the new owner engaged in community outreach, et cetera, et cetera. How, no one has made any findings at this point. What parts of the record do we accept? You have an affidavit filed in connection with your brief by the Director of Uses, Mr. Castellani objects to that. Could you speak to how we should view what's in the record at this point?
Well, Your Honor, you know, this just came up on a motion to dismiss. So there was never the ability for the BRA to file as its answer the entire administrative record. But the BRA board memo is the best evidence before you, and that appears in the appellate record at page 185.
Okay, and that was, and why? That's because that was submitted before the judge in Superior Court?
Well, that was submitted as part of the filings in the Superior Court, but it is also the legal conduct of the BRA. The BRA only acts through its board, and the board vote is what is reflected in the board memorandum, and the reasons that support the board vote are also reflected there. Also, the chronology of the proceedings are summarized in that board memo.
In the procedural posture we find ourselves, don't we take the allegations of the plaintiff's complaint at face value and as true, drawing reasonable inferences in his favor and without regard to anything outside of it?
Yes, that's true, Your Honor, but taking every allegation in this complaint in favor of the appellant still does not grant standing.
No, I understand your point regarding the merits, but this is related to Justice Vuno's question, which was, what is it that we can properly look at in deciding this case? Isn't it just limited to the complaint, the allegations of the complaint? This is not, judge didn't look at anything else. It doesn't appear.
Well, no, the judge did have the BRA's opposition, which included the board memo and the urban renewal plan. So
right.
Those points are part of the record.
No, it doesn't matter that they're part of a record if they can't be considered. So, we're pretty clear on what can and cannot be considered on a motion to dismiss. Now, if what you're arguing is that these things can be considered under some exception to the ordinary rule for motions to dismiss, I didn't see that in your brief.
Well, it's the agency conduct. It is the evidence of what the appellant is attempting to overturn. So the court must have to operate from the framework of a set of facts of what, but even just using the plaintiff's complaint, you can clearly uphold the Superior Court decision on the issue of standing, and you don't have to get entangled with Article 80 and judicially reviewable. So I respectfully request that be the court's ruling. Thank you.
All right, well, thank you both very much. I'm just going to check with the panel to see if there's no additional questions, and I see none from the panel. I want to thank you both very much for your patience today in terms of the time that we called you for your argument and for your preparation in your briefs and your presentation today. It was very helpful. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Begin with the arguments. I'll introduce the panel. My name is Ariane Vuno. I'm joined today by Justice Gabrielle Wallahojian and Justice Eric Nyman. You each have 15 minutes, as you both know, I'm sure. You both also know that there's no rebuttal in the appeals court. If we experience any technical difficulties, we will resolve them as soon as possible. Please continue to be patient, and I will assure you that no one will lose any time as a result. With all that preamble, Attorney Zendrasky, you've already been before us today, so you know all the information you need to know. Please begin your argument.
All right. Good morning. May it please the court. My name is Matthew Zendrasky, and I'm here representing the defendant, Mr. Perez. This appeal concerns one issue, whether the search warrant in this case was defective, where Detective Jeanette's affidavit and the jurat attached to his affidavit were unsigned. So the statute and the case law, Dozier, particularly require that a search warrant or an affidavit supporting the search warrant must be signed and sworn to in front of a justice or a magistrate. And in particular, this case, I believe, hinges on the Truax case. And so in that case, the court held that the magistrate must be informed of the basis of the informant's knowledge and the circumstances from which the affiant in particular concluded that the informant was credible. And so in this case, there was Detective Mello's affidavit in support of the search warrant, and that was properly signed, and jurat was signed properly as well.
Would it be fair to say that Mello's affidavit effectively incorporated by reference Detective Jeanette's affidavit?
Wouldn't
that be a fair reading?
I would say that it would incorporate Detective Jeanette's affidavit as an affidavit. If the language in Detective Mello's affidavit itself says Detective Jeanette provided this detective with an affidavit attesting to the aforementioned investigation, which is attached and marked as attachment number 1. And so it seems here that the intention was to include Detective Jeanette's affidavit as an actual affidavit, as witnessed by the language, affidavit, and attesting.
Attorney Zandrowski, are you saying that nothing can be attached to an affidavit that's submitted in support of a search warrant?
No, that's not my argument.
Okay. So for example, there's a second attachment to this affidavit, and your argument doesn't affect that attachment. That attachment, in your view, could be considered even though it's not independently signed and sworn to.
Correct. It's
okay. And would you also agree that the contents of the first attachment, if I forget who the name of the attesting, the Mello, if Officer Mello, if his affidavit said, this police officer from Rhode Island gave me the following information, and cut and pasted the entire contents of that attachment 1 into his affidavit, and Mello's signature and the jurat appeared at the end of it, that would be okay, that all of that same information could be considered?
In this case, I would say no, particularly because it was Detective Jeanette's affidavit dealt with a confidential informant. And so that particular bit of information does change that from, I think, your hypothetical.
Is there a case that says that you can't consider information that comes from a confidential informant unless the affiant has firsthand knowledge of it?
I believe that is the Truax case. I apologize if I'm mispronouncing that, but that case specifically stood for the proposition that the magistrate must be informed of the basis of the affiant, how the affiant concluded that the information was credible. And so in this case,
it's the affidavit, and that may have been a defect in my hypothetical. If the affidavit said, I got this information from an officer in Rhode Island who, I believe is credible, and then it's copied out everything from the Rhode Island officer's affidavit, which also established that officer's basis of considering the CI reliable. Is that not a permissible form in which information can come to support a warrant application?
I guess I'm not sure I understand the difference between the two hypotheticals to answer that.
If the basis of knowledge is sufficiently revealed, does it have to be, why does the affiant have to be the one who himself dealt with a confidential informant?
Well, in particular, I think that's still the Truax case, which does have the language from what the affiant concluded that the informant was credible. And so I don't think that that's present in Detective Mello's affidavit here. There's no, as he didn't have any.
All right. So, but that would not be a procedural defect. That would be a defect. What you're saying is, in other words, it wouldn't make a problem with respect to the signature or the jurat. You would just say it was insufficient to support issuance of the warrant.
Well, I think that I guess my argument is that the lack of the signature knocks out that affidavit, and then it was insufficient. The remainder of the search warrant application was insufficient in this case because Detective Mello doesn't include any details of any interactions with the confidential informant. So, standing on its own, that affidavit doesn't provide any basis to issue that search warrant.
So assume the facts of this case are exactly the same with the one exception. And that exception is that Detective Jeanette signed the Rhode Island affidavit before a magistrate. Everything else is precisely the same. Probable cause to search?
I would concede yes, that if that affidavit was properly signed, then it would be properly included, and that the failure here is that the lack of the signature and the lack that it wasn't sworn to in front of the magistrate.
So how do you square that with the Bass case?
With the Bass case, I believe they held that was controlled by Truax. But in particular, I think both cases involved the unsigned additional pages were authored by the author of the primary affidavit. So their failure to include reference to their additional pages when it seems that essentially they ran out of room or they did not have enough room to include the information in their affidavit, that's my reading of those cases, that it was, in that case, it wasn't defective because they were clearly meant to be read as one affidavit and they just didn't have room to include the signature. It hinges on the single authorship of both cases.
I was under the impression that Bass also stood for a little bit of a broader proposition, which is that the technical violation, for lack of a better term, is not a deal breaker when it is clear or reasonably clear where the information stemmed from. Mm-hmm. Am I misinterpreting?
I would say that would still be controlled by kind of back to Truax, which was where Bass more or less came to their conclusion with, where they also in Truax held that formal defects in formal defects in the work product of the police, careless and unnecessary defects in the form and construction of the affidavit may constitute violations. That's at the end.
I'm sorry for interrupting you. Did the Mello affidavit indicate that Mello had spoken with this Rhode Island detective and received information therefrom?
It did indicate that the Mello had. I'm not sure off the top of my head. I'm looking at it right now.
I think it does in the record appendix 24.
24.
Fourth paragraph down, at least in part.
Oh, I apologize. I misunderstood the question. Detective Mello's affidavit. Yeah, it does indicate that he had worked with Detective Jeanette.
So reading that and then reading the sequential nature of the affidavit with the attachment, why doesn't that sort of provide that clarity that our court was discussing in Bass?
I think it goes back to the idea that it seems that from Detective Mello's affidavit that the extra affidavit was attached as an affidavit itself. And so I think that's what makes it different, is that language, that this was an affidavit. It's not just.
In some ways, doesn't that make it better?
I don't believe so. No, I think it would have been better if there was an affidavit with the sworn information.
No, but I mean better than just a delineation of information that wasn't sworn to, that wasn't provided by a source with knowledge and experience and all these other sort of factors.
Well, I think it wouldn't make it better in that would be referring to a source, Detective Jeanette, who's then referring to another source, his confidential informant. So we're getting removed from the actual information which came from the confidential informant.
Okay.
And, so I think if there are no further questions, that's about all I have by way of argument.
You don't deal with the fact that the attachments, each page of every attachment has been initialed. Can you address that a bit? I mean, it looks to me like one of the initials is pretty clearly that of Detective Mello. And the second one, it might be, but I mean, and the Commonwealth argues the initial of the magistrate.
I'm actually not sure the province of the initials. So
are we just supposed to figure that out on our own and make our own inferences?
Well, I think at least I don't have any record that would indicate that was Detective Jeanette. I know the affidavit isn't signed. And at least for my argument, the fact that the jurat isn't signed is, I think, an even more critical piece of information because.
Well, but there is a jurat that is signed. What isn't signed is an attachment to that. What doesn't contain an attestation is an exhibit to a properly executed and attested affidavit.
I wouldn't characterize that as the exhibit. It does say it's an attachment, but it's presented as an affidavit. And so the jurat on attachment 1 is not signed.
Okay. So if it hadn't been set up as an affidavit, and this goes to Justice Nyman's question to you, it just was like statement of Detective Jeanette, just a typed recitation of facts. Doesn't say affidavit, not set up as an affidavit. There would be no problem here, other than your argument about the weakness of importing that information. There would be no procedural defect. Am I correct?
I think that goes back to Truax, where the affiant, we're looking for information that the affiant has concluded that the informant was credible. And so I'm arguing in this case, that's Detective Jeanette.
I hear you on the substance of it. I'm trying to focus on the lack of the form of an affidavit that's signed and sworn to. If it were just a statement, just a paragraph typed out, and Mello said, I received this recitation of facts from Detective Jeanette and identified who Detective Jeanette was. Are you arguing that a kind of an attached document would be required to be signed and attested to?
Because it dealt with a confidential informant, yes. If it weren't for that.
And what would be your legal authority for that position?
The Truax case. That's what my argument comes from. So I would rest on my briefs if there are no further questions.
I don't believe so, but I'm going to double check with the panel. And it seems that you've satisfied or you've answered their questions that they asked us. Thank you very much. So we'll turn now to Attorney Kidd.
Thank you, Justice Funo. Again, I'm Rob Kidd. I represent the Bristol County DA's office. I want to just start by apologizing for making the court wait and counsel wait. I told the clerk's office completely didn't put it on my calendar. I don't know what happened. My bad. It hasn't happened before, but anyway. Getting right to the meat of the argument. Here we have a police officer, a local police officer, Bristol County police officer, who fills out this affidavit, this application for search warrant. On the application for the search warrant, he does what he is supposed to do. The clerk is there. The detective signs that affidavit, Detective Mello. There's a jurat next to it. The clerk witnesses it. The detective attaches to that affidavit, to that application, his own affidavit, and that affidavit is also properly attested to by the clerk.
Can we, let's stop for a second. Justice Vuno, can you still hear us?
I can, and I'm just plugging in a cord, excuse me. I can, please continue.
Okay,
Sure.
so I just wanted to make sure you had not been discontinued.
No.
Yes. So as I was saying, Detective Mello's affidavit was properly witnessed. It was signed by Detective Mello, witnessed by the clerk as well. And then Detective Mello attached the affidavit of a Rhode Island detective who set forth the facts supporting the probable cause regarding the confidential informant. My understanding of the case law is that there is no requirement according to Truax and other cases, there is no requirement that the attachments to the application be witnessed by the clerk magistrate or that there be a jurat. Even if that were the case and that were a requirement, here we have certainly ample evidence of Detective Mello's intent to incorporate Detective Jeanette's affidavit. First of all, Detective Jeanette specifically.
Well, the one thing is that Detective Mello identifies this attachment as an affidavit, and it's actually not an affidavit. It's a document set up in the format of an affidavit, but it's not an affidavit because it's not actually signed and sworn to.
Correct, but it's not technically an affidavit. But I think the question of whether it is an affidavit or not an affidavit misses the mark.
It's not an affidavit because I'm sure under Rhode Island law, which no one has bothered to tell us, there are requirements for an affidavit. And my guess is this doesn't meet it because it's not signed or sworn to. So when Detective Mello says, I'm referring to and I'm incorporating or I'm attaching an affidavit, that's actually not what he's attached. So why isn't that a problem?
It's not a problem because I think Your Honor was getting at it before in some questions. What would happen if the detective in this case had, instead of attaching an affidavit, had attached a police report?
But then he would have said in his affidavit, I'm attaching a police report. But that's not what he says in his affidavit. He says, I'm attaching an affidavit, but then he doesn't attach an affidavit.
Correct, but what he attaches is what he intended to attach. His understanding was that was obviously he understood it to be an affidavit because it looked like an affidavit, like as the saying goes, looked like a duck, quacks like a duck. It was not signed, but it was. I mean, it's obvious that it was intended to be incorporated because, as we talked about, the page numbering system was consecutive. Jeanette's numbering system started. Mello's numbering system spilled over into Jeanette's affidavit, and it continued continuously. He also specifically mentions in his affidavit, Mello mentions talking to Detective Jeanette. And we know, and that's how we know that Mello's affidavit is based on information he got from Jeanette. He also says that he refers to it as an attachment, and in fact, Detective Jeanette's attachment 1, I think, and Jeanette's document is labeled attachment 1.
Yeah.
So whatever.
The attachment also looks like it was transmitted to someone by fax, and that it's missing the first page of that fax. So, I mean, what do we make with that? We've got an unsigned document that's apparently missing its first page. And I mean, for all I know, the first page said, look, Detective Mello, here's my draft affidavit. It's still a work in progress. And then Mello takes the next 3 pages.
I don't, hold on, just 1 second, Your Honor.
I'm looking at page RA 27. I also noted the date on that fax was about a week before the date of Mello's affidavit.
I understand that question, but I don't know that that's a problem. The way I look at it is simply and it's in the simplest form. Detective Mello spoke to Detective Jeanette. They were working on this investigation together. Jeanette faxes Mello over this affidavit, and Mello attaches that what you say is not an affidavit, that document. He attaches that document to his affidavit, and he refers to it specifically. He numbers it consecutively, and he, I believe, as we said, there is some indication that the clerk magistrate also may have put his initials on that, indicating that the clerk himself was present viewing that attachment himself. So for all those reasons in my brief, I think there's enough, certainly more than enough, to infer that Detective Mello intended to incorporate that document that he got from Jeanette.
So assume that the Jeanette document does not constitute an affidavit. For purposes of this case, does it matter?
No.
Why?
No. Because we already have an affidavit. The law requires, it requires an application, and it requires someone to set forth the facts, usually in an affidavit form, that the application is based on. We have that. We have the application properly executed. We have an affidavit of Detective Mello properly executed and witnessed with a jurat. Mello is entitled to attach police reports to his affidavit. He's entitled to attach unsworn statements to his affidavit if he wants to, and it's up to the clerk magistrate to review that to determine whether there's sufficient probable cause. So no, my answer is no.
Let me ask you a slightly different question, which is, of course, we review the issue of probable cause within the four corners of the search warrant application, and we can do that ourselves de novo. But here, some of the issues that have been raised involve whether or not what Detective Mello was doing or not doing, or intended to do or not do, and there was perhaps a fax that had arrived earlier. Are those questions of fact that should have been resolved in an evidentiary hearing, because they don't really go to probable cause, which we would lie in the four corners of the affidavit?
I guess I'm not. And I know Justice Wolahoji referred to it. I guess I'm not getting the relevance of the fact that the affidavit was faxed over to Detective Mello. I don't understand why that is an issue. I think that happens in law enforcement. I mean,
well, let me just ask you this question instead. Let me put it in a more generic way.
Sure.
This is a procedural, an allegedly procedural defect with the issuance of the search warrant. All right, this is what's being alleged. And so if that is the case, if there were a more apparent egregious procedural problem with the information that was submitted to the clerk magistrate, would that be something that would have to be resolved through an evidentiary hearing or rulings by a lower court judge? Is it outside the four corners of the affidavit, is my question.
I don't think so. I don't think that what we have before us here is something that needs to be resolved. I think it's clear on its face. I think it's clear on its face. I guess I'm not answering your question, but
no, I'm thinking about an analogy, for example, to a Frank's hearing. In other words, if the allegation was that the police officer was misrepresenting something, that would, if it rose to a certain level, that would call for a hearing. And It would, even though we're talking about the four corners of the affidavit, that would be something outside of that.
Correct.
So my question just is a general matter. Should there be a procedural issue that's raised to a certain level? In your view, would that require evidence?
Yes. I mean, if the affidavit and the attachments indicate some sort of malfeasance on the part of an officer, certainly, but I don't think we have that here.
I'm not suggesting anything. I was just asking a general question about what we might need to resolve the issue.
Yes.
And there was a non-evidentiary hearing held in this case, correct?
Yes.
But there's no transcript before us. Am I also correct about that?
That's correct.
Okay.
So, I mean, and just to follow up, so for example, you ask us to draw what to me looks like a logical inference about who made the initials on every page, but that actually didn't come up in any kind of evidentiary context, right? So that we don't have any findings, we can't really make findings in the first instance.
Yeah, I think you can, though. I think you review, everything is de novo here. So you sit in the shoes of the judge, the trial judge, the motion judge here, and you can make reasonable inferences from the affidavit, from the submissions.
Is that as to procedure, or is that as to probable cause?
I'm not sure. I'm not sure where you're going with that question. I'm sorry. I'm a little.
Well, for example,
what do you mean by procedure?
if somebody said, excuse me, if someone said those are not those initials, that was the allegation, then there would have to be an evidentiary hearing to determine.
I see what you're saying. And yes, I mean, if this case came down to those initials, I suppose if this case came all the way down to that, yes. But I submit there's a lot more evidence than just the initials. But that's for your honors. That will be your honors determination, I guess.
Right, but and to follow that up, we understand your point of view. But for example, if you were asking us to rely in a more substantive way on those initials to show what was before the magistrate judge, could we do so on this record?
I think I'll check it. I have a footnote here. Let me just check it out here. I think what I said in the footnote was one of the initials was very clear.
You thought that Detective Mellows was very clear, and that perhaps the other one was the magistrate's.
Right. So, I mean, I think Detective Mellows, with Detective Mellows' initials on every page, it's just further evidence that I think it's crystal clear evidence that Mello intended to incorporate the other affidavit into his. As to the clerk's initials, I mean, yeah, if you want me to, that's not the state of the law. My understanding is that the clerk does not have to, put a jurat on all of the attached pages of the warrant application. So I think the government is in pretty good shape here, if to use the vernacular.
Does the panel have any further questions for Attorney Kidd? I see none. Okay, I'm going to. I presume you're ready to rest on your brief at this point. Am I interpreting? Yes. Okay, great. Thank you both very much. Thank you for your arguments, and we'll take the case under advice.
Yes. Okay. Thank you. Bye.
We are live.
Okay, thank you very much. Good afternoon. Our final two cases for today's sitting of the appeals court involve the same parties, and they are paired for argument. It's MM versus EM, and the numbers of the cases are 2019-1790 and 2020-1301. With regard to the first case, I understand that Attorney Landauer will begin, and because our second person argument is a student practitioner, Ms. Blesses will continue that argument for a total of 10 minutes, and then Attorney Landauer will argue the second case for 10 minutes. Before we begin, I'll introduce the panel to you. My name is Ariane Funo. I'm joined today by Justice Gabrielle Wolohojian and Justice Eric Nyman. If we have any technical difficulties, please be patient. We will resolve them as soon as possible. And I can assure you that neither one of you will lose any time as a result of any potential problems. In this case, only one side is appearing, and that is the individuals that I've already introduced, and they represent the party EM. We have not received a brief from MM, and nor is that person indicated that he wants to be here to argue. All right, so with that said, we can start the timer, and we'll hear first from you, Attorney Landauer.
Thank you.
1 second, there we go, go ahead.
May it please the court. My name is Attorney Margot Landauer. I'm here along with recent law school graduate and 303 student attorney, Ms. Ariana Flesas, on behalf of appellant wife EM. My argument will focus on docket number 2019-1790, which we filed on July 7th of 2020. Ms. Flesas will focus her argument on the second and related appeal, docket number 2020-1301, filed on February 16th of 2021 and consolidated by this honorable court on March 4th, 2021. Your honors,
May it please the court. My name is Ariana Flesas under Rule 303.
Your honors, we are here today to ask the court to vacate both the 2018 and 2020 209A orders against our client appellant EM. We argue that the mutual 209A orders issued by the Quincy District Court in both 2018 and in 2020 were erroneously granted. Your Honors, our client is a long-term survivor of domestic violence who suffered ongoing physical, sexual, emotional, and verbal abuse at the hands of her ex-husband throughout the course of her marriage. As the record shows, specifically in Appendix 1, pages 11 through 23, our client, the appellant wife, suffered years of serious physical harm established by medical records, which included several hospitalizations. The Quincy District Court judge did not adhere to the stringent procedural requirements required when issuing the 209A mutual restraining orders in both 2018 and again in 2020, and failed to identify our client as the primary victim of domestic violence in the relationship.
Were you saying, in other words, that the judge failed to issue written findings as required by the statute?
Yes, Your Honor, we are arguing that.
So when the restraining order issued and no written findings were made, was any action taken before the trial court judge? Or did you ever ask the judge to make those written findings?
Your Honors, our client was pro se until March of 2020 when she secured representation through the Domestic Violence Institute at Northeastern University School of Law, which is the clinic that I operate, and Ms. Flesses has been a participant for the last 2 years. So the answer to your question is no. There was no motion to revisit or ask to be put in front of the district court judge. The first motion was the initial appeal that we filed last year.
So that begs the same question, which was, would it have been the best practice to file some sort of a motion? I think there are different tools that can be used that are available to get it before the trial judge in the first instance. Or I should say, in this case, it's not a trial judge, but before the trial court.
So, Your Honor, at that time, we had felt that the case was moot, and our client had come to us. She had already filed the appeal at that time. So she had come to us, she had sought assistance for the appeal. So when we revisited the extension of the case in 2020, that was when the judge actually issued a written finding of fact. However, that written finding of fact is very generalized. She alleges, the judge in her finding of fact, it does not adhere to those procedural requirements. She states that generally that the plaintiff is in fear. She doesn't, in her findings, state that the parties are mutual aggressors and explain that both parties, as determined by SOMI, that mutual abuse has occurred.
You're going to have to explain to me exactly which case you are referring to at this moment. So we're going to shift to only hear from you at this time, Ms. Flesses, so we can understand what's going on, even though the arguments overlap. So again, the date of the order that you are talking about.
Yep. So yes, Your Honor, this is the 2020 case. So it's the docket 2020 P 1301.
Yes. I mean, the date of the order issued by the district court.
September 25th, 2021.
2020.
In docket number 1301, our docket number 1301,
Yes, Your Honor.
the only argument that's made in your brief is the sufficiency of the evidence to support the issuance of that September 25th, 2020 order. So that appears to me the only argument you've raised in that case. Do you want to direct your argument to that? I understand that it's in the other case that you raise the absence of findings with required for mutual restraining orders.
Yep, Your Honor. So that's where Attorney Lindauer will speak about.
Right. So am I correct that you don't raise this findings for mutual orders issue in 1301?
You're correct, Your Honor. We don't.
Okay. So why don't we just stick, since you're arguing 1301, why don't we stick to the arguments that you've actually raised?
That would be you, Ms. Flesses, in 1301, right?
So Attorney Lindauer actually is the.
I'm going to be arguing the issue of appellee MM's failure to meet the abuse standard, which was included in which was the crux of our argument in 1301.
All right, so Attorney Plessis, why don't you use the remaining of your time to address the question that Justice Wolhogen raised, which is whether or not there was sufficient evidence for the restraining order to issue. And that is an argument that is made, as far as I can understand, in both cases, but you are only going to address the issue in one of them. Is that right?
Yes.
Okay.
I'm really sorry to do this. Who is arguing 1790? I have a lot of questions in 1790. I need to know who is arguing 1790.
I am, Your Honor.
Okay.
All right. So
So
let's let Ms. Plessis just
If
finish
no-
her 3 minutes, and then we'll turn it over to Attorney Lindauer. All right? I think that's the best use of our time. Go ahead.
Your Honor, Judge Wolhogen, given your specific question around 2020, you are correct that the crux of the brief in the 2020 appeal is about the sufficiency of the evidence. Attorney Plessis was also arguing that, which is not included in the brief, that the mutual orders in that case also did not adhere to the stringent protocols, though that is not a fundamental.
That's waived.
Correct. Do you want Ms. Plessis to continue?
She only has 2.5 minutes to finish her argument, and she's been given permission to argue before us, and so she should finish, and then we will turn to you, and we'll have plenty of time to ask all the questions we want.
Thank you.
So, Your Honors, even though that argument has been waived, so we do argue that the orders in 2020 are mutual orders. And we do argue that they are mutual orders due to the fact that mutual orders under the guise of the law are determined to be reciprocal orders. And it doesn't matter, as determined by SOMI, that mutual orders are, whether they're issued on the same day, the same court, any of that. And so they're an extension of the 2018 order. And so we argue that the lower court had the 2020 case actually gave the lower court a chance to actually remedy that finding of fact. So Justice Newman, you brought up this issue where we could have potentially filed that motion, and our client came to us after already filing the appeal, and that's what she sought our assistance for. So we went to the lower court for her extension hearing and to defend her in that 2020 hearing. And so on that date, the lower court asked us what the issue was on appeal. And we stated very frankly in the transcript that there was no finding of fact. And so the judge had the opportunity to remedy this. However, the problem in that finding of fact is that the judge, it was a generalized statement. And SOMI states that you cannot have a generalized statement. You have to have a specific written finding of fact.
So are you saying that the judge did issue written findings?
She issued a written finding. However, her written finding does not constitute a real written finding.
Is that in the record appendix?
It is, Your Honor.
I didn't see it. I apologize.
Where is it? Is it just part of the transcript that was issued? All right. So in other words, because it was a teleconference. All right. So there was an oral finding.
It was an oral finding, and it's also a finding of fact on the order issued. And it's very generalized, and it just states that the plaintiff is in here. Attorney Lindauer will also address it.
Okay, and she actually has the opportunity to address it right now because your time is expired. Unless the panel has questions of you specifically, which I don't see, then we'll turn it over to you, Attorney Lindauer. Okay.
Thank you, Your Honors. May I start?
Yes, you may.
Okay, great. While the argument in our first brief related to the procedural failures of the mutual orders issued in 2018 may be technically moot because Appellee's husband's 2018 order was vacated when he failed to appear at the extension hearing on September 11, 2020, we argue that when the Quincy District Court extended his new 2020 restraining order to align with our client's 2018 restraining order, that the 2018 orders were reignited and therefore the mutual orders were reignited. Your Honor, there is
a question. I have a bunch of procedural questions, Attorney Lindauer. I'm looking at the notice of appeal in docket number 1790. The lower court, and actually, I believe that what you're appealing is a September 2019 restraining order. Is that correct?
Your Honor, yes.
Let's look at the notice of appeal if you don't
Yes,
mind.
no, yes, Your Honor, the 2019 mutual restraining order.
All right. And the lowercase docket number in the case that you're appealing from ends in 0070, correct?
Yes.
And yet your notice of appeal that's appended in the appendix, it comes from a different case. It bears a different docket number.
Your Honor, we didn't file the initial notice of appeal. Our client did so pro se.
Okay, so my concern though is that this is not the correct notice of appeal. Let's even assume that it is. Let's assume that it is. It may refer to a September 4th, an October 4th restraining order, but there is no October 4th restraining order.
Your Honor, we believe that that was the extension of the 2018 orders that were consolidated.
Okay, but it's not the date. There's no date. The court didn't issue an order on October 4th. So I'm wondering what we're dealing with here. But let's even set all of that aside and assume that somehow it's been properly appealed, that the September 13th 209A was properly appealed. Let's just assume that right now for the purpose of argument. In 0070, there have been at least 2 subsequent extension orders. What relief can we then give you on a superseded order? In other words, even if we vacated it, the subsequent 2 orders still stand. It's not like the earlier one falls and then that means all the others fall. They're subsequent orders. As far as I can tell, they're not appealed. There's nothing in the briefs or the record to indicate that the subsequent orders have been appealed. So why isn't this moot? We have case law that says that the subsequent orders supersede the previous order. And that previous order is not appealable.
We would argue, Your Honor, using Utaro versus Otaro, citing Utaro versus Otaro, which cites Bello v. Johnson, which is an unpublished opinion, that while the case may be moot as a practical matter, the case is not moot in the legal sense because the importance of assuring the proper judicial administration of restraining orders is of great significance to the court. We argue that when the Quincy District Court in September of last year, when they realigned MM's new ex parte and then 10-day order with our client's existing 2018 order, the initial mutual restraining order was reignited. And in many ways, it's an extension of one case because
they're 2 different cases. They're 2 different actions.
There are 2 different actions, Your Honor, but the appellee uses a variation of the same set of facts in his affidavit from 2020 that he used in 2018.
I'm not being clear. So let's assume you've got 4 orders like this, okay? Initial order, subsequent orders. and you appeal only the second one in the chain. Is that the case that was involved in Utaro, where there were subsequent orders that have not been appealed?
Your Honor, one moment. I'm not entirely sure, to be quite frank.
Well, there is an appeal, is there not? Just so I'm also clear, from the order that was entered on 9/25/20.
Yes.
But that's in a different case.
That's a
not-
different case. I just wanted, but there is that, and that is set to expire 9/10/21. Is that
Yes,
right?
both our client's extension from her 2018 restraining order and the appellee MM's new restraining order were realigned, and the hearing on those two cases is scheduled in the Quincy District Court for September 10th of this year.
Okay, but so my question remains, Attorney Lindauer. In docket number 0070, there's an existing order that has not been appealed.
Yes.
That continues to September 2021.
No, sorry, Your Honor. That order has been appealed. That's the one we're appealing in 2020-1301.
Isn't that docket number 731 down below?
That is the 2020. That is the.
There are two different cases.
In your view, that is the appeal from what was entered on September 25th, 2020, in
Yes.
your view?
Yes.
But
And Justice Wallholden is pointing out a discrepancy,
Yes.
my understanding. Okay.
There's no notice of appeal from the order issued in 2020 in docket number 0070, as far as I can see. Can you point me to one?
Your Honor, one moment. Your Honor, it's not in the appendix, but we definitely filed a notice of appeal.
But that's not part of this appeal. If you filed a notice of appeal, maybe has it been appealed? Perhaps you can straighten this out with some kind of, I'll tell you what it appears to me, and I've gone through it pretty carefully through all your stuff. It looks like I'm gonna, in case 1790, our docket number 1790, which is an appeal from underlying case 0070. There's a defective notice of appeal. However, if we overlook those defects, it might be that you have appealed an order issued on September 13th, 2019. It also appears that that was a one-year order that has subsequently, there are subsequent, at least two subsequent one-year orders that have not been appealed, or at least there's no notice of appeal for them.
I think there's, is there one or two? Isn't there one that comes after? I just want to double check. After,
Yes,
the
there might be only one, the one that goes from September 2020 to September 2021.
Correct.
And in our appeal number 1301, which is underlying case number 731. Okay, it's a different case. You're appealing an order issued on September 25th, 2020.
Your Honor, I think I can.
And I think there is a notice of appeal for that case for 731.
Yes, that one, it looks like to me is an order.
Correct.
It's the 1790 that I have a question as to whether there's any meaningful relief we can give you, because you have not appealed the subsequent orders in that case. In other words, even if we were to agree with you about the order that issued in 2019, it's been superseded.
Yes. It has been superseded by the restraining order issued on September 25th, docket number 2056 RO731.
No,
And is your point that we should still look at the other case because it's not moot because of the importance of the fact that the trial judge did not issue written findings? And that's the important factor that renders this not moot?
Your Honor,
Am I correct about, is that your argument?
we have two arguments. One is the argument that you just said, that because the trial court didn't issue specific written findings, that the procedural rules and the law around mutual restraining orders wasn't adhered to. And the second argument is that the appellee, in this case, MM, didn't meet the statutory definition.
All right, so the second one, I don't think, I'm just going to say potentially does not fall within, would not abrogate the mootness doctrine, because that's a typical argument that we see. The other argument is something that can perhaps carries more weight, which is that you think that when we're talking about the regulation of these orders, that the judges should abide by the statute and do exactly what they're supposed to do when they issue a mutual order. Is that right?
Yes, Your Honor.
Okay. I'm going to leave it to Justice Wojciechowski for a few more questions. I see your time is up. And so whatever questions she has, I don't see she has none. Justice Nyman, do you have any questions?
Oh, thank you.
All right. So thank you very much for your argument. We'll take the case under advisement and get back to you as soon as we can.
Thank you, Your Honors.
Thank you.